Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
We're here at Radio Law Talk. I'm Frederick Penny, your host. The important people that are next to me is Todd Cunin. The reason I bring that up is he just returned from a science camp, and we're going to talk about the importance of being at science camp and what he learned. And then Denise Dirks to my right, and Harvard Prince, the Prince of Peace, Harvard man, Chris Rodriguez to my left. And behind the glass, thanks Cal Hunter, our producer, for producing this great show, and our helper today and call screener, Grant Bear. Welcome, Grant, for filling in for Seth Madden. We got a lot of fun things to talk about today in our 3-hour segment. First of all, we'd like to thank Crack Radio. We always like to thank Crack. It is out of Red Bluff and Redding area. It is our mother station. And we are excited to note that starting November 11th, the Nevada Talk Network will be picking us up in Nevada. So it's going to be exciting. We're going to be blasted throughout Nevada. Radio Law Talk continues to grow and grow and grow, whether we like it or not. And so that means our salaries are going to go up and up and up.
Well, they don't don't really have room to go down, do they?
I noticed everybody just looking at me like, what?
I had a 500% salary increase. Of course, 500% of zero is still zero.
Zero.
And,
That's exactly.
We all do this for the love of law.
Yes.
Yeah, we do. So a couple of topics we're going to talk about today is Johnny Depp suing his lawyers. That's going to be a very interesting one. Again, when we talk about that, the complaint has been filed. I'm sure there's going to be a cross complaint and or answer. We have not seen that yet, so we have to put a disclaimer in there. This is Johnny Depp's side of the argument. And then we're going to talk about what's called 5 Points in New York. Some art was demolished, and the question comes down to whether or not graffiti is art, and whether or not once they put graffiti on a building that they actually did to kind of promote the area, once the area kind of took off and went from a slum area to a valuable piece of New York, they tore it down and are building high-rise buildings that are worth a lot more money. And the artist and graffiti artists, and the question is whether or not it's art, are suing the developer for tearing down their graffiti. And this is not like the typical graffiti, and we're probably going to try to throw some pictures up, but man, it's some really nice art. And then St. Regis Mohawk Tribe is suing Amazon and Microsoft over some trademark infringement. And then we're going to talk about the Honest Ads Act. The Honest Ads Act. It comes from a bunch of politicians. And again, this is Radio Law Talk, where when you're tired of politics radio, you listen here, because we don't talk about politics, but we talk about the law. But you know, politics does roll into the law to some degree, but we don't pick sides. We just argue both sides. Remember, we're talking about general topics of law. Seek counsel from your local qualified attorney, and that's an important thing. Today also what we're going to do is do Cal's favorite thing. What is that?
Case?
Yeah.
Or no case?
It's not my favorite.
Fred.
Case or no case? What case or no case is? Yeah. Yeah, sure. What case or no case is, for those of you who don't know, it is Cal Hunter, our producer, comes up with these cases, and they're either true or false or fake or real, and then we decide whether or not, number one, it's a real case, number two, given the facts and the evidence he gives us, whether or not someone's going to win or lose, and then we want you to tweet in or call in and give us your answer. Tweet us, Denise, or call us. How do they get in touch with us, Denise?
They get in touch with us at 855-LAW-RADIO, and that's 855-529-7234, or tweet us at Radio Law Talk.
Yeah, so case or no case, you can chime in and tell us what you think of the case, and then we're going to be discussing that.
And remember, if we're wrong, our heads blow up.
That's true.
So watch us on YouTube as well.
There you go. Our heads do blow up.
Watch our heads blow up.
Okay. Wow, that's an interesting one. Talk about science camp. Really, just he wasn't here last week because he rolled. Oh, you were here.
I was here last
week. No, he was here last week, but he didn't. He just rolled in late from science camp. We didn't have time to talk about science camp.
I rolled in late today because I was chaperoning my son's 6th grade class, along with all of the other 6th graders in his school, to Alliance Redwoods up just north of San Francisco in Occidental.
There's your shout out.
And it was great also because a lot of, last week we talked about the wildfires. So they were housing at this campground a lot of the firefighters that were still working at trying to control these fires. They were also housing families who had lost everything. And so the kids were, here you had our kids were sitting there eating dinner, and you had families that were just a couple of tables down that almost literally were probably wearing the clothes off of their back that they were able to get out with, who had lost everything. And it was a great way for that. I mean, given the circumstances, it was good for the kids to see how lucky they are. Our kids to see how lucky they are and how quickly things can change, and to be grateful for the things that they have. But the camp, it was great. I will say that when you are in a small cabin with 9 kids ages 11 to 12, there are smells that will come out of that cabin.
Let's point that out, boys.
And boys, although in talking with some of the female chaperones, it was just as bad. Because I mean they're exercising and they get back. It is just like it's walking into a sauna, but there's no sauna, and so then you start wondering where that steam is coming from. And there are NFL locker rooms, hockey locker rooms that would be offended by the smells that came out of those rooms. But
how did you contribute?
Nothing. I was as pure as the driven through snow, and so. But all in all, it was a really positive thing for the kids. They really enjoyed themselves.
Did you get to see the banana slug?
We did, in fact. Not only did we get to see the banana slug, but I have pictures of each one of the kids putting the banana slugs over their nose.
Yeah.
And they had to leave it there for 10 seconds. One of the one of the teachers from my son's school said, I figured out that I learned the wrong way, that if you put the banana slug on your lips, it will be numb for a while, because it's a
little toxin.
Yes, a little toxin that makes things go numb, and then so we didn't let any of the kids do that. But it was still really good. They got to do zip lines, swings, climbing. I got to do a couple of those things, although once they hit the weight limit, I had to bow out.
It's so interesting you talk about the toxins in these banana slugs, because Cal told me before the show one of his case or no case options involves the use of banana slugs in the bedroom.
Wait a second. You got information prior to us getting anything on a case or no case?
With cats.
Oh, jeez. Stop. No comment. On a roof. So, probably people are listening going, what are they telling you? You have to go back to listen to all the podcasts. By the way, they're still working on our website. The podcast will be listed, just so you know. Those of you who see our podcast, it just has the date. There will be titles coming forth that'll state, they'll state what the actual shows are about. So you just don't have a date of a show, but that's coming. But probably the most important thing that I didn't bring up that we really need to talk about, and we're running at the end of our segment, but on November 3rd, 2017, what is that significant date, Cal? What is the most significant thing about November 3rd, 2017? That is a very significant date.
First Saturday in November?
November 3rd, 2017.
That's this year.
That's coming up.
Next week.
That's next week. It's the most important date, probably close to Christmas.
Love is in the air.
Don't know.
Black Friday.
It's about love.
C-Rod, do you love it? Do you know? No?
I have no idea.
Todd knows. Don't say.
I know what it is.
All right. What it is Love Your Lawyer Day. It's a special day called Love Your Lawyer Day. I am not kidding those of you out there. It is Love Your Lawyer Day. And we're going to talk about Love Your Lawyer Day, what you can do on the 3rd of November 2017 to Love Your Lawyer Day, created in 2001 by attorney Nader Anasi, whoever that person is.
Hear past episodes of Radio Law Talk on radiolawtalk.com. Just click on the podcast tab. Happy listening.
Yeah, you notice they cut me off on Love Your Lawyer Day? I think it's because it's a preemptive strike. Oh, he's talking about Love Your Lawyer Day. We're cutting him off.
I haven't seen anything in any of the department stores. I haven't seen little stuffed lawyers for sale, little judge robes, none of that. I'm sick about it.
Well, here's I'm sick about it too. We are here at Radio Law Talk to bring out important aspects of life and the law, and that's why we're here to tout Love Your Lawyer Day. And I would like you guys to each give me a few instances that people could help out on Love Your Lawyer Day. And Rodriguez came with a good one, and so did Todd. Rod, what was your Love Your Lawyer Day? What's the thing you should?
Very simple. Pay your bill.
Pay your bill. That's a Love Your Lawyer Day. That's a good idea because the lawyers need to be paid.
Plenty of clients, they don't give their lawyer nearly enough love by paying their bill.
Okay, that pay your bill. That's a good Love Your Lawyer Day. Todd, what's Love Your Lawyer Day?
Let's see here. Your Google search does not replace my law degree.
Oh, that's... I love that. It's like, Mr. Penny, you're not right. And Google said, oh, okay.
Yes.
Denise, Love Your Lawyer Day.
Just because I make it look easy, don't think it doesn't take me a lot of time to do it well.
Ooh.
So appreciate me.
Oh, you know what I say? Just don't Love Your Lawyer Day. Let's just get rid of the Love Your Lawyer Day because it ain't working. Started in 2001. How many years is that? Last time I checked, that's 16 years ago.
That's right up there with Love Your Ex-Spouse Day.
That's true. Ex-Spouse Day.
May I see by a show of hands how many have gotten cards or flowers or any such of a thing on Love Your Lawyer Day? Yeah, I did.
I'll tell you right now, I'm sure I've got a card or two, but it didn't say Love Your Lawyer Day.
Yeah, some clients celebrate something Your Lawyer Day every day of the year.
So the most important thing here in Radio Law Talk is November 3rd, 2017. I know all of you running out there and marking it on your calendar. Love Your Lawyer Day. Do something special for your lawyer. That's it. Okay. All right, so we talk about in Radio Law Talk this important aspect of Radio Law Talk that helps you out in life, which is teaching you a little bit about the law and discussing the law generally. And then, if you need more specifics, run to a local lawyer. But what's going to help you more than anything out there is listening to Case or No Case. And we've got Case or No Case.
Now it's time to play Case or No Case.
Listen, I recognize my cue. Not all that.
That's right. Well, at least you were talking about Love Your Lawyer Day.
Yes. By the way, is that such a thing as cruelty to slugs? Is that like something the SPCA would get involved with? Well, never mind. Anyway.
Coincidentally, Love Your Lawyer Day is also synonymous with Love Your Slug Day. So,
I think the slugs will get more.
Slugs get more love.
I thought it was Shark Day.
All right, now.
Okay, this is starting off really slow.
It's my turn for a bad joke. Hold on.
Okay, well, we're going to wait till music, and then he can tell us the wrong musician. So that's why
So you're telling me there's a chance.
All right, so now I take you out to the lovely village of Austin, Texas.
Ooh.
Austin, Texas.
Home of the Longhorns.
Yes. Where a woman is walking in a retail establishment. I'm going to leave out a little wild card factor with the original setup here. She's walking in a retail establishment, just minding her business, shopping along, trips and falls and breaks her ankle. The woman is awarded $80,000. And now the wild card in the story. The child over which she tripped was her own. Case or no case? Chris Rodriguez.
I'm going to say, since she was awarded $80,000.
Well, this is just a theory. I was just putting it out there.
I'm going to say that she has a case, and I am going to say that the reason she has a case, there must have been some sort of an attractive nuisance in the aisle of the establishment that caused her toddler to stop and look, and she tripped, so it created a dangerous condition. And she probably was represented by Fred or one of his partners.
Actually, I do have an Austin law firm partner up there.
Yeah, I mean,
who knows? I should call him.
$80,000 for something like that. Only Fred could get that result.
I think I can. I think I can.
Denise Dirks, did a woman trip over her own child and get a check from the store for $80,000?
Yes, I believe so. Was it a store or a mall?
A store.
Retail establishment. Yes, I think that when you're in a retail establishment, it's common knowledge that you walk around and you're looking at things, not necessarily paying attention to what's on the floor, and that she did trip over her child, and she did win $80,000.
Isn't this akin to, I don't know, having your own bag of marbles, dumping them on the floor and falling on them yourself? I mean, where's the responsibility of the mother over the child over which she tripped? It's her own child.
It's foreseeable that somebody can trip over a child.
Todd, case or no case? Am I making this up, or is it true?
You know, I heard once, and I know that this is a criminal law issue, but somebody once said that you can indict a ham sandwich, which tells you how easily indictments are secured. And I would say that if that is true in the criminal realm, that when it comes to personal injury, it is just as easy to file a case. And from my perspective, putting aside all of the elements, if the case can get filed and somehow make it past summary judgment, then the retail establishment would probably say it's easier just to give you $80,000 than to go through all this garbage, because, as Fred would say, you don't want to sue old ladies, you probably don't want to sue moms about their kids, and it's just not worth the hassle. So I'm going to say case.
No, wait, no, now, Fred, everybody's agreed that's a case.
Okay.
So the real question is, was the,
up my alley,
if in fact it was an award, was it a settlement, or did a jury give her the dough?
Okay, here's the California law, and most states are generally the same. It's generally the same, but it's going to be a little bit different. We got 1 minute to go. I'm going to roll it in, and we're going to find out after the segment what the answer is. A dangerous condition has to exist that they knew about, the store knew about, or should have known about. That's the general question you ask yourself, whether or not the store is going to be liable. Did a dangerous condition exist that they knew about or should have known about? The facts you gave us, the answer is no. But I'm assuming there's some facts that you haven't told us specifically, and I think C-Rod brought it up, that it's important to note probably there was an attractive nuisance, or the kids stopped because of one of the employees walked in front of them. I don't know. I'm going to wait till after that, after the segment, to find out whether or not there's more facts. But like everybody said, you can win any case. And do I believe that there's a case? Yes. Do I believe it was a settlement? Yes, it was a settlement.
A settlement, not a jury award.
Not a jury.
How many of you say jury award? Hands. One. So that means 3 of you say settlement. Well, we'll answer that question and more when the show continues here, RadioLawTalk.com. Stay tuned. The answer to case or no case is coming right up. It's RadioLawTalk.com.
Case or no case, lady trips in Austin, Texas over her child. We've got basically 4 yeses, it was a case, but...
Three believe that the establishment settled with the plaintiff,
right.
And 1 believes it went to jury.
Well, let me give you the answer, if I may, ladies and gentlemen. Case or no case? That's the core question. How many of you said it was a case? All of you, correct?
Right.
Yes.
All of us. What? So I was right. I did say that there's no dangerous condition existed that should have or shouldn't have existed. Wait.
When I first found
it did not show that there was any dangerous condition.
I first found the case and I started doing some research into it, and I found a total of 6 different versions on the internet, one of which said she was awarded $780,000 because it's a false case.
So this is fake news?
It is fake news. Well, that's what case or no case is about.
Case from the panel.
But I did have Chris convinced when I gave the award amount.
Well, the only thing I knew for sure was if it was an award amount, then it wasn't a settlement. Otherwise, we wouldn't know about it.
Oh, good point.
Right?
Yes.
Because
Very good point.
because if you're a business and you're going to settle with somebody, the first thing you're going to have in that agreement is a confidentiality clause, because you don't want want to know. You don't want the public to know you just paid someone $80,000 for tripping over their own kid. The next day, you're going to have 400 moms with their kids walk into that store, and they're all going to trip.
I like the fact that you said, Chris, that we would have won that case, our law firm. Thanks.
Absolutely.
Well, now we know that all the facts that were given are not necessarily facts.
See, case or no case, and he stumped the panel. Good job. It's like, what's that old game show? You could stump the panel to tell the truth?
To tell the truth. I didn't. Yes. Remember that when I say case or no case, I did not use the operative word, so shame on me. Alleged facts. I did not say that.
Yeah.
And I'm sorry. I apologize.
I would have guessed differently had you said that.
You would have still stumped me,
Let's
Cal.
do some updates. Tiger Woods. We talked about Tiger Woods. On Memorial Day, he was arrested for driving while on prescription pills. He just pled to reckless driving. Now, that is basically what the prosecutor would give him as a lower sentence. Isn't that correct, Todd? They'll say, hey, let's lower it down to reckless driving.
Yeah, and
it's a first offense for him, too.
Yes, because the previous incident that he had with his spouse with Thanksgiving was also pled down to a reckless driving oriented offense. But the interesting thing about this is when you read the news, they all make it sound like he got some deal because he's a celebrity, and somebody said he has to plead to this, and it's very salacious the way they make it look. Tiger Woods got what everybody else in Florida would have gotten. I would note that in California, in the county that we broadcast from, they really don't have this type of a program for resolution. But Tiger Woods got what everybody else would have gotten on the same set of facts, which is diversion. He pleads to something, he takes a class, and then he's able to withdraw his plea after a year after he's taken everything.
And he basically goes through a term of probation.
That's right.
And he has to honor the terms of his probation. And if he does, he can make the actual underlying thing go away.
It will go away by operation of the agreement.
Right.
I don't understand how this is news. Anybody who's watched Tiger Woods play golf in the last few years knows he's guilty of reckless driving.
That's exactly right.
He hasn't hit a fairway in 4 years.
Putting for that.
I mean, all of it.
All right, that's a good analysis.
I needed the rim shot.
Yeah, guess what? Though here, 12 months probation, a fine of, ready for the fine? I don't know if you can handle it. $250. $250 fine, but 50 hours of community service. And I think part of that community service is he needs to come to Radio Law Talk and be on the show with us.
I would absolutely love that.
You are invited. By the way, it's heard here live. You can come on down to Radio Law Talk, Tiger, and we will discuss the legal issues.
Are we live in Windermere, Florida right now?
We can be.
Not yet.
Windermere, Florida.
Although online
Pick us
we are,
up.
sure.
Okay.
Yeah. Don't forget, tests revealed he had 5 drugs, Vicodin, I don't know, all these different, Xanax, 5 different drugs in him.
But apparently no illegal drugs.
No.
Prescription.
But he's won 14 major tournaments in his career. I didn't realize 14.
The biggest issue in this case was that there was no observed driving. So the biggest hurdle for the prosecution was going to be, all right, you have to prove somebody is under the influence at the time they drove. He was found passed out behind the wheel of his car.
But he was pulled up, was he on the side of the road, or was he parked kind of in the road a
He was
little bit?
on the side of the road. He had flat tires, but the hard part for the prosecution was going to be which drug was it that impaired him? When did it impair him? There were too many hurdles there for them to reasonably say that we have a chance at convicting beyond a reasonable doubt. Quite frankly, I think that the plea deal, to a certain extent, demonstrates integrity on the part of the prosecution, where they say, look, if we don't have a case, we don't have a case, and this is what we're going to do.
So Todd, if you're defending him, all right, what do you put on as a defense? Or do you just put on no defense and say that they haven't met their burden? Because you're not going to convince anybody that he drove over some curbs, ran into some bushes, has flat tires, and then he ingested all these drugs because he was so bummed out.
Well, if I was defending Tiger Woods, the first thing that I would have advised against was making a statement that I took this combination of drugs and it affected me adversely because you're basically admitting to impairment there. I would not have made any statements to the press, to the public, in connection with the case, because the case is still pending and anything you say can be used against you.
And it's not an intent crime. You're looking at, did he voluntarily take the drugs?
That's right.
That's all. I mean, and it was a combination that caused impairment. That's all you need to prove.
Absolutely.
Well, guess what? There's another update that's important and talks about our marijuana laws. It just came out in the Sacramento Bee, October 25th, 2017, an article on a Los Angeles lawyer that has been sentenced to 4 years in federal prison for his involvement in a large-scale marijuana cultivation operation in the Sacramento and Sutter counties. Now, we pegged it, the first lawyer getting arrested for doing marijuana. Federal. But here's, okay, so it's the federal. Remember we got the states, we had an issue between the feds and the state fighting each other as to whether something's legal or illegal. Don't forget, when you scratch your nose, we're on YouTube. So they're going to show it. Looks like you're scratching your nose. It looked like something else, Todd. But okay. So anyway, here's the interesting part about this whole thing. And Todd, you brought it up. Todd brought this up. This started in 2011. That's the issue. It started now, if he's doing it now, he's probably no problem. They're probably not going to prosecute him.
No, federally they will.
Well, they can, is what we say. They can, but will they now, Denise, is the question.
Judge Sessions says he's going to go.
But I don't know of anyone, but this started 2011 when these laws had not been passed.
True.
Therefore, they're nailing him. But just think if he started it today, would they go after him when the state law says it's legal?
Well, here is, and this is an issue that comes up. For example, give you an example. A couple years ago, when they changed certain classes of felonies from felonies to misdemeanors, folks could come in who had previously been convicted of those felonies to go in, and they could then have them reduced to misdemeanor to reflect what the current status of the law is, and that worked. So if this were a state prosecution, right? And it had started out in 2011. Once the new law passed, they probably would have dismissed the prosecution because they would have said, look, even if we convict you, we're convicting you of something that's not a crime for you to do now. But we have identified on this show the difference between state and federal law, and the fact that the feds did not dismiss the case in California after the law was passed could very well be a signal to everybody else. The feds are saying, it's still a federal offense, and if we're not going to dismiss this case, we may be coming after people who try to engage in this behavior. It could just be, we're not dumping it, and the reason we're not is because it's still a violation of federal law. Now, we also don't know the extent to which he was really involved in the trafficking, and there might be some other issues here, but still, it's interesting that they didn't dismiss it after the change in state law.
No, they didn't, and like Denise has stated, and that we've gone back and forth here, is what's going to happen between the feds and the states bumping heads on this issue. I know in the state, the sheriffs, they're not doing much about it right now. I mean, in California, it's white, they're just kind of, I know I was talking to one of the sheriffs, they're like, yeah, we just, we got other things to deal with. And so, my thing is timing's everything. This guy missed his timing. But what's interesting is he was over 5,000, 2 industrial-sized marijuana cultivation sites in Sacramento and Sutter County, and it was over 5,000 plants that they pulled from him. So that's some big stuff. Yeah. 2,168 plants were seized, and about 3,300 plants at the Cal Nevada nursery. So
interestingly, they Willie Nelson. They disposed of them.
Nelson, it's all gone to pot.
And they disposed of these plants in a nice fire during the campfire at Alliance Redwoods. And that's why the kids all slept so well.
That's exactly right.
I'm kidding.
So anyway, when we come back, we're going to talk a little bit more about the Johnny Depp thing. We're going to be pushing that later, though, in our program. Probably hour 3 is we're going to talk about it. But we're going to discuss this New York buildings that were torn down that had all the graffiti on it. And we'll be right back with Radio Law Talk.
Thank you for listening to RadioLawTalk.com. Don't forget, you can listen to all episodes just by going to the website, RadioLawTalk.com.
I can hear her heartbeat.
Is graffiti art? That's coming up right now on RadioLawTalk.com.
Every time she smiles.
C-Rod, what should our Radio Law Talk graffiti, gangs have graffiti and stuff, what should the Radio Law Talk graffiti look like?
Oh man, we are such a street-hardened group of folks here.
Right.
I think it really we need to commission somebody from the streets.
Right.
It needs to be authentic.
I think the rule is the difference between us and the graffiti and the gang graffiti is we're going to pay people to do it for us. we'll pay big bucks to have someone do like our graffiti, and it's probably going to have something to do with the scales on it, with maybe a gun on it.
I was just going to suggest booger art. Just
Booger, B-A?
Oh no. Okay, we need to thank Sidney Colbert from University of San Diego School of Law. He has done the research for our program today, and he's done a really good job and really fun topics. The topic of 5 points is.
It's a boy. I'm sorry, I don't remember.
I'm not sure, but
Sydney. I hope it's not. a girl. I don't know. Sorry, Sydney.
Did I say he?
You said he.
Okay, well, Sydney, I assumed you're a person. So.
You know what? And Radio Law Talk, go ahead and tell what we do with this and why. What happens?
We have a program that gives scholarships to law students who provide our research for our program, and it's a really good program. It helps us. It helps them. And this topic that Sydney has covered for us in this segment is, for me, really fun.
Well, guess what? Well, hold on, Cal. Give me some voice. I don't have any voice right now. Hold on, Cal. Oh, there we go. Cal's got my voice back.
sorry, Fred. My bad.
That's okay. Sydney, I want you to tweet us right now and say, I'm a boy or a girl. As bad as it sounds.
I'm not designating.
Guys,
I'm not designating. Oh, wait. Sydney's, he's got a picture of her. She's beautiful. Sydney's gorgeous.
Hold on, let's see.
Okay, Todd got a picture of Sydney.
You guys, and I was going to say...
So, Sydney, sorry. That's... and that's Denise's fault.
Viewers, here we go.
You guys are
Sydney,
really
beautiful.
dating yourself. To even think that somebody named Sydney that's in law school now would be a boy? Nobody has named their boy Sydney since the 60s.
All I got to say is, luckily it was Denise that brought up Sydney, not me.
My bad, Sydney. Sorry about that. But let's get into the topic,
You guys
guys.
remember Melrose Place?
Yes.
Okay, I think
like Sid.
Yeah.
Haven't you heard of guys called Sid? I mean, it's a common name.
Sydney's back there listening. Let's hope she's listening going, wow, they're really talking a lot about me. I'm getting some good kudos.
Yeah.
Well, she did a really good
She's
job.
gorgeous, too. What a beautiful woman.
She did a great job. If anybody is out there that is looking at Sydney's resume and thinking about hiring her in the field of law, we strongly suggest that you do, because her work was phenomenal.
Yeah, and Sydney, record that and use it for your next resume. So go ahead. Sorry, let's talk about the law.
Okay, so we have
graffiti
in
New York.
Brooklyn, New York.
Well, Long Island.
Artists-
Long Island.
Well, the building's in Long Island.
Right.
The suit is in Brooklyn.
Gotcha.
The artists that did the artistry and the graffiti on the building of 5 points. It's known as 5 points. You can look it up in Wikipedia.
Do you know what that means, Denise? 5 points?
Yeah, it's where five different boroughs come together.
Right.
And
Cool.
boroughs are like counties, right?
Yeah, that's cool.
Yeah,
That's
or
cool.
little townships or whatever. So they all came together, or they all created this, and now they're trying to claim their art. And they're trying to claim their art under the Visual Artists' Rights Act of 1990. So the question is graffiti art or visual art?
Okay, so let's just summarize the facts. These artists, phenomenal artists, painted these gorgeous, huge graffiti murals on this building called 5 Points, or in 5 Points.
Yeah, the building was owned by Walkoff, and he let them do it. They did it with his consent.
Okay, let's stop right there. Let's back up even further, Chris. This was a very bad part of town. There was prostitution, gangs, shootings, death, and it was such a bad part of town. He thought about, how am I going to bring this up, and let's bring the graffiti guys in, gals in, and do this graffiti art. And what happened?
It went further than that. He said, let's bring in the artist, period.
Right.
Not just graffiti. And he rented out office space at a low discounted price for artists, not just graffiti artists. So it was art in general. And the question became, is graffiti an art, a work of art? I personally believe that graffiti is a work of art. But under this act, the artist has to make a claim to it. And also, the most important part under this act, if you're going to destroy the art, you have to give a 90-day notice to the artist that you're going to destroy the art.
The Visual Art, just FYI, Visual Artists' Rights Act of 1990 is what it is.
Right, and so the owner of the building, after this art had been on the building for several years, decided to tear the buildings down to build something else.
Whitewashed.
Whitewash the building.
Whitewash the building. He eventually will tear it down, but he whitewashed the building without giving the requisite notice. That's really at the heart of this. So the question
A lot of it
becomes,
is already torn down, though. It's already been torn down, a lot of it.
well, now, but
now,
not at the
right,
time that
right,
the suit was
right,
brought. It wasn't. They were actually bringing the suit to stop the tearing down.
Right.
And it wasn't just limited to graffiti on the building. There were beautiful art projects all around the building.
Right.
There were like statues and pottery and different types of shrines and
Yeah,
stuff
and just
like that.
actually just like little walls that weren't even part of the building that were painted with the
Exactly.
graffiti.
And if you go and you look it up, I mean, the pictures are amazing. What happened then, the artists came into this Long Island City, into this particular area, and took over, and they made it their own, and it raised the values of the property
Way
such
up.
that
Yeah.
this building owner decided that he wanted to get it developed. He wanted to ultimately tear it down. So what did he do? He whitewashed it without giving the requisite notice. So the question is, what's the damages for not giving the notice? Well, if we get past the first question, which is this art that's on this building, was it
Right, under the
visual,
act,
the
under the
work
act.
of visual art that gives the artist the right to make the claim? And if they get past that hurdle, which I personally believe they do, I know that Chris does not believe it's going to be there, but I believe it. They will. Then it's going to be what's the damages for the 90-day failure to give notice.
But they have to claim it, right? Tell me
do.
about that. Tell us about that part of the law. You have to actually claim. You can't just go do art or do some graffiti and say, "Oh, you took my graffiti down. You owe me money." You have to have claimed it somehow.
Right. So these artists, in order to make this claim, have to show that they demanded that their name be used in conjunction with the display of the work, and that's going to be one of the major factual hurdles, I believe.
Right.
Next, the author has to enjoys the right to prevent use of her name as the author of that work. So they have a right to stop other people from claiming that that's their artwork. And remember, this is hundreds of thousands of pieces of artwork potentially that was on a building. Third, the author may prevent use of his or her name as the author of work of visual art, although they might not have created it. That's subject to distortion, mutilation, or other modification that could be prejudicial to their honor or reputation, and that's where I think this one lies, is really there.
Okay, and I know that we're getting deep into this federal statute, but my brother is not a lawyer, and he always tells me, look, Chris, I know you're a lawyer, but you have no common sense. And we've had this discussion many times over the years, and he's really right. And our law does a pretty good job, for the most part, of following common sense. There is a person who owns a building in New York. These artists were allowed to paint on the building. They knew they were painting on somebody else's building. As a matter of common sense, when the artist does that, they know that that building isn't going to be around forever. You don't get to put a painting on a building and then say, "Ooh, that's my building now. You can never do anything with it."
Right.
So I don't believe that there is a court that at the end of the day is going to say that these artists can prevent the owner from doing what he wants with their building.
By the end of the day, no, but they may get damages, because if he gave the 90-day notice and he's going to tear this building down, they could have gone in and protected their work of art.
How?
By tearing off sides and pieces of the building that's going to be destroyed. That's my argument.
Interesting.
So
Todd and I are just sitting here looking at each
Yeah.
other, shaking our heads.
And
Going,
the-
"What person here?"
The thing is, they can't prevent the destruction or distortion of their art. It's already been done. So it's really going to come down to, can they seek
So
damages?
sorry, Cal. Todd's got his hand up first.
One thing that I would say here with all of this is we are talking about something that's called graffiti and tagging. The name in and of itself should convey the transitory nature of whatever you're doing. If it's graffiti, I do graffiti, I do tagging, I think you are inherently saying this is something I agree can be.
But I'm going to argue with Denise a little
Yes.
bit, but guess what? He brought them in as artists
Exactly.
to do this. That's a little different
consented.
argument.
Yeah.
He consented.
He consented.
Did they have the right to copyright the material?
I think they did, but I don't think they did it though. So therefore, we're going to wrap this up. This is the end of the hour. Come back next hour and talk more about interesting topics on the radio. I'm Frederick Penny, Radio Law Talk. Read us.
Yeah, Radio Law Talk.
You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated. Is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
We're rolling back into hour 2 of RadioLawTalk.com. I'm Frederick Penny, your host, with Denise Dirks, Chris Rodriguez, and I was going to say Dave Cunin, but I think I'll call you Todd Cunin today.
Yeah, you might get sued by my brother for defamation if you called me.
That's exactly right. And then
Okay.
Cal Hunter behind the glass, our producer, that is a 3-time Emmy Award nominee. He always reminds me, nominee. What a great person behind the glass, and thanks.
NorCal Regional Emmy, often nominated, never a winner.
That's okay. You're a winner in our book because you were nominated, man.
Thank you.
That's all that matters. And then we've got Grant Bear helping us out on the phones. Give us a call at 1-855-LAW-RADIO, and we can talk about anything you want to concerning the law. Don't forget, Denise Dirks is a family law lawyer. I'm a personal injury lawyer. Todd does criminal law, and Chris Rodriguez does employment, corporate, and basically general litigation, trial civil litigation. So we have most of the bases covered here, but usually what we do is we try to switch subjects during hour to hour, but we've got to follow up on this 5 points case we were talking about the hour before, which had to do with the graffiti and the art on this building in Long Island City and it being torn down. Go ahead, Denise.
Yeah. This building housed Crane Street Studios, in which 200 artists paid below market rate rents for the studio space. And the owner of the building, he allowed for them to, his name was Jerry Walkoff, and he allowed them to do their own graffiti, and it was aerosol paint graffiti specifically on this building. And this building really became recognized worldwide. And if you look up 5 points, that's 5 POINTZ, you will see that in Wikipedia it's listed, and there are beautiful pictures of the graffiti that was on this building. Now, this building, after it became this art studio, if you will, and was painted on, it really did help to change the nature of this of the location and the community around the building, where the criminal elements went out as the artists came in. So the artists actually helped to rise this community up, and also helped to raise
awareness of the area.
Right, awareness of the area.
Wow, the art is just gorgeous and beautiful. But go ahead, Cal, you have a question.
But they're being compensated for the art, so they've been paid for it. The guy says, okay, enough, it's my art. I've paid for it. I'm going to tear it down. I don't want it anymore.
Well, because they had reduced rents. Is that why you say they've been
Right,
compensated?
but they've been compensated.
But here's the question. So here's what's interesting, though.
Yeah.
All you hear about is that, okay, they tore it down, bad. Todd brought up some interesting points about the concessions the developer gave to the city in order to get this passed, because they're putting up high-rise buildings that are apartment buildings that are going to be more valuable. But mention those concessions that he gave in order to do this.
So originally he just wanted to put up a high-rise, have a 1,000 units for high-rise residential location. It was rejected, so he came back and said there'll be 210 low-income housing units. He also proposed, I believe, a 12,000 square foot center to continue the Cohen's ability to curate graffiti art, so there would continue to be this ability for people to come in and put art in this 12,000 square foot center that he had, as opposed to the 200 1,000 square foot warehouse that they were using.
It was kind of an ugly, beat-up building. It was old.
So basically, he was proposing to create.
He did propose. This is actively.
His proposal was to create a residential area with the art being the centerpiece of the residential area, and so he was seeking an accommodation, if you will, and that didn't happen, and it didn't meet with agreement from Cohen. It's interesting to note here that Cohen, the name that we are talking about, Cohen was the person that Wyckoff hired to sort of curate the graffiti artists to come in and create their graffiti murals on this building. So the guy that Wyckoff hired to sort of oversee the graffiti is now suing Wyckoff so that he can continue to do what he was doing and to protect the art. And Wyckoff proposed a plan whereby he could continue to do that.
Well, it's after the fact now. The building's been torn down.
It's been torn down.
So now they're trying to sue for damages, and that's Denise brought up a good point. Even though she's on the one side and Chris is on the other, Denise says, "Okay, but what's their damages?"
So I want to focus on a provision of the law here that I believe negates any right for damages. And tell me if I'm wrong, Denise, because you've been looking at this longer than I have. But it says this is an exception for artworks that are incorporated into buildings. It says, whenever the incorporation of the work of visual art into a building is such that removing the work from the building will cause the destruction, distortion, mutilation, or other modification of the work, the integrity right, which is what these artists are trying to enforce, is inapplicable. So, and that seems to be the place where common sense comes in. If you put a piece of work into somebody else's building that in order to remove the art would destroy the building, then you don't have that integrity right that would entitle you to 90 days notice.
But the argument is they're tearing it anyway.
They were going to demolish the building anyway. In fact, the artists were not against him demolishing the building. They were just against him destroying the art. And so we need to get to the part where the codes, there's four parts of this that have to be shown, right?
Yes, and my computer crashed on me.
How can you do one without the other? How can you destroy the building without destroying the art when it's like on brick or something?
Well, I mean, some can and some can't. I guess it would probably cost to be, I would think, to protect it and to save it would cost a lot of money to save those walls. It's going to be, and this is an old beat up building, it's old, and it's going to be difficult to save it. But this is, we're talking about the Visual Artists' Rights Act of 1990.
So in order to establish a claim, they have four elements that the artists and Cohen need to establish. One was that the work was a work of visual art. Two, that the art was of a recognized stature. 3, the art was or will be destroyed. And 4, the art was copyrightable.
That's exactly it, and I'm on the side that I'm of the artists. I think they can show it, and they don't have to show that it was copyrighted because there's an exception that it could be copyrighted right at the time of creation.
And note here it says copyrightable, so it's something that could have happened. They didn't need to do it.
Right.
But I view these four as being, these are the bare minimum you need to even bring a claim. It doesn't negate any defenses somebody might have.
Or exceptions that exist.
Or exceptions, but this is what needs to, before you even get out the gate as a plaintiff, you got to have these four in place.
Right.
I think that they satisfy all of those four. I don't even think that there really is a close one there, but that body of law applies just generally to art. You know, can you art on canvas, art on posters? You know, this is art on the side of a building, and there has to be some common sense that comes in, and where the rights of an artist that would exist if they were painting on a canvas conflict with the property rights of somebody that owns a building upon which they painted their art.
Right. I still think it's going to come down to that untested 90 days notice. I still feel like if he had given them 90 days notice, then some of the artists at least would have approached him and said, may I have this piece of wall?
And how are these artists that are graffiti artists, I guarantee have no money, going to take that wall down in a proper manner to save it that's going to cost probably hundreds of thousands of dollars.
Thank you.
Exactly. The law
going to happen.
The law does not require a futile act.
Right.
And so the owner of this building can say, look, even if I had given the 90 days, these artists were not going to be able to afford to spend $100 million to take this art off of the wall. So that would have been a futile act, and the law doesn't require me to do that.
Oh my gosh! What I'm shocked about is we still got 1 minute left. What I'm shocked about is there's so many people out there that have money that are art lovers that would not donate to this cause to have it taken down and pay for it to be taken down. I'm a little shocked about that. And then this whole thing could have been alleviated.
Well, what makes me upset about it is they were actually, these artists were trying to stop it, the demolition, and he went in and whitewashed it. He went in and actually destroyed actively before it could even be decided.
Now, tell me exactly how you feel.
I'm sorry. I'm taking the position.
Denise loves art, and we all love art, but anyway. So we're going to come back and talk a little bit more about the St. Regis Mohawk Tribe suing an Honest Ads Act. So we'll be right back with Radio Law Talk.
Hey, tweet us at Radio Law Talk.
Hear past episodes of Radio Law Talk on radiolawtalk.com. Just click on the podcast tab. Happy listening.
We're back. We're going to be talking a little bit about this lawsuit by a Native American tribe along with SRC Labs about some patent law. But before that, those of you who have joined us the first hour, every hour we do a case or no case. And what case or no case is, and you can tweet us in at Radio Law Talk and tell us your answer, what you think is. Cal Hunter has not disclosed any of the case or no case to any of the four of us, and he will tell us the facts and the issues, and we're to determine, number one, if there's a case, and number two, whether or not the case, who won the case, and what the damages were. So, Cal, roll it.
Now it's time to play Case or No Case.
Fred, Federico Centavo.
And now,
Federico Centavo.
see, Frederick Penny.
Yeah, Federico Centavo.
Now, ladies and gentlemen, of the distinguished panel of lawyers on RadioLawTalk.com and all of the myriad of listeners out there in radio and internet listening land, I take you to the beautiful community, the Stoner Village, the unique locale,
Cal's hometown, what was that?
Portland, Oregon.
Portland, uh-oh.
I take you to Portland, Oregon. There's a gentleman who apparently, according to my case or no case, whether it's true or not, I'm not saying it's true, but there's a gentleman who went to a company based in Portland, Oregon called Nike. Perhaps you've heard of them.
Okay.
And sued Nike for multiple millions of dollars because they used Michael Jordan's image in advertising, and this gentleman claims that he is Michael Jordan's doppelganger, and therefore the ad campaign is causing him untold damage. Is it a case or no case? Frederick.
Wait a minute. His what? Doppelganger?
Doppelganger.
Doppelganger.
Someone looks exactly
Like his twin. Everybody has a doppelganger, they say.
There may be several Fred Penny doppelgangers out there. In fact, we'd encourage you to
I feel sorry for you. I think there will be on October 31st. Someday, Cal, I hope someone's wearing a mask with my face.
Who's suing, though? Because I don't get
The doppelganger.
Okay, the doppelganger is suing.
He's claiming he's repeatedly mistaken for the basketball star. It slows him down in his life. It slows him down in his work. Therefore, it's Nike's fault for using Michael Jordan's image, causing this other gentleman, the so-called twin, irreparable harm and life disruption. Case or no case? Chris, what do you think?
Before we get into that, I will be shocked if there is a lawyer who is representing this doppelganger. He's got to be representing himself, because there is no chance that this is a case. Zero chance.
Now, you have to remember, before you say that they're already running ads in Santa Rosa, law firms by the dozens, coming out like little bugs at night in the kitchen, not my kitchen, but some people's kitchens, for the
buyers.
Yeah, saying, hey, you could probably make some money off of this deal.
Hey, what are you calling Fred? A little bug?
I'm just saying.
Oh my gosh!
In other words, lawyers will do pretty much anything if they believe that
they're there. They're out there.
Yeah.
Believe me, those guys and gals are out there. They'll take whatever.
But we will say this about those lawyers: they do have legitimate help to offer these people, right? I mean, so anyway,
well, yeah,
that's a whole different discussion.
We talked about that. You weren't here last week.
It was just the ambulance chasing aspect of it that kind of I thought would verify Fred's point.
Is everybody pointing at me? Why isn't everyone talking about me? Because I have cards. Because I have my picture on the top roof of the ambulance inside. Is that a problem? What's wrong with that?
Your doppelganger probably has a suit against you.
That's exactly right.
So Fred,
For intentional infliction of emotional
Wow.
distress, right?
The answer is here's the answer. I'm not going to get into the first hurdle. I'm going straight to damages. There's no damages. Absolutely, this case was brought. Yes. Now, I agree with Rodriguez. I believe it was improper, means he brought it by himself. No lawyer would have brought this up. But there are no damages here. I say, yes, there is such a case, but no, he loses and there's no damages.
$832 million would be a number I'd just pull out of the air of what he was asking for. I'll just pull it.
Well, in that case, yeah, he wins. He wins. Okay, I'm switching.
So you say no case. If there were a case, it was filed by the man.
No, there is a case, and it was filed. It was improper by himself, because I think, Chris, even the lowest of low lawyers wouldn't take that one. And there's no damages, so zero. But the $832 million did sway me a little bit.
Was this filed in a state court or a federal court?
State court in Portland, Oregon, I
So
believe.
it involves Oregon laws.
Oregonian laws, and you never know what they say.
Well, I'm an Oregonian.
So you know what I mean.
Come on, Oregonians, top of the roof, they're all out there.
So Denise, case or no case?
I'm trying to make up a theory that it could be a case, because it just stinks the right way that it's going to be a case. I just know it, because I've been on the wrong side of the case or no case for the last several weeks, right?
No damage.
So, I'm going to say, if there is a particular state law that says that you have to advertise and use the image name, the person's image who you're using in the advertisement, and Nike failed to do it, there might be a case.
So if they didn't identify Michael Jordan as Michael Jordan, the guy would say, well, see, that's me up there. Right, okay. So that's your theory. All
Yes,
right.
I'll probably be wrong, but...
Chris, you've already given us your view. Do you want to add anything on that?
The only thing I could think of is if this gentleman has a picture of himself dunking a basketball with his legs spread wide, just like the Michael Jordan logo, and he can come up with that, then maybe we got something to talk about.
There we go. Todd is
Mr. King, as you study and research, tell me, by the way, no Googling allowed during this.
I'm Googling something else.
Okay, no Googling and no wagering. This is a...
He's Googling redwoods. Alliance Redwood Forest.
Yes,
Look
I
for the
am.
pictures. Well, I know they took a picture of me somewhere. I saw the guy.
Case or no case?
I need to ask a clarification
Yes,
question.
sir.
When you answered Denise's question about jurisdiction, did you say it is Portland, Oregon, I believe? Or did you say Portland, Oregon, as far as you know?
Okay. Either is acceptable.
It is absolutely a case, but it was filed by somebody whose real motivation was just so he could meet Michael Jordan someday, and it didn't succeed.
Okay, well, we're going to come back and get the answer from Cal after this break. I'm Frederick Penny, your host of Radio Law Talk.
Hey, tweet us and give us your decision. Is this a case or no case at Radio Law Talk?
Someone please tweet us.
And the answer is coming up. Case or no case on RadioLawTalk.com.
This is no fun.
Oh, it's not that bad. It's RadioLawTalk.com.
I think this case or no case is no fun because it's a weird one, Cal. We have some weird ones, but I think this is a weird one. So go ahead and tell us. And go review it. Let's just review again basically what happened.
Sure.
Go ahead, Cal.
A gentleman in Portland, Oregon sues Nike and the owner of Nike for over $800 million, claiming the fact that they use Michael Jordan in their advertising has caused him irreparable harm because he is Michael Jordan's essentially identical twin.
Wow.
And so it's an inconvenient thing. It's bothering him. It's making him crazy. And he wants something done about it. So he goes after Michael Jordan slightly, but mostly after Nike. And so, Denise, let's just very quickly poll you again. Denise, case or no case?
Well, I said it was a case based upon an Oregon state law that says if you use somebody's image in advertising, they have to say their name.
Have to identify them.
Identify them.
Fred Penny, case or no case?
Yeah, I said it doesn't even matter. I said yes, absolutely. Someone brought that case. I think it's an improper case, which he brought it by himself. But there are zero damages. But again, the $832 million really kind of might almost change my mind to say, yeah, that's a good
Made
case.
you think about it.
I might take that one.
Todd Cunin.
I say it's a case unless it's not a case.
Good one.
That's your depends answer.
That's a lawyer.
Heads I win, tails you lose.
I say it's a case.
You say it's a case?
Yes.
Chris Rodriguez, case or no case?
No case, but it does remind me of a case, and I, like Fred, believe it has been filed. I once saw a case that was filed in the Sacramento County Superior Court that alleged sexual misconduct by Donald Trump. This was well before he was president, Oprah Winfrey, Mike Tyson, and I don't remember the fourth celebrity. But people can sue and say anything they want. It doesn't mean that they have a case. I believe it was filed, and there is no case and no damages.
The answer is man sues Michael Jordan and Nike. Portland, Oregon resident Alan Heckard sued former basketball star Michael Jordan and Nike founder Phil Knight for Fred's magic number, $832 million, claiming they have made Jordan such a recognizable figure that he suffered personal harm from being repeatedly mistaken for the basketball star. By the way, within a month, he dropped the lawsuit. So he filed it, and then within a month dropped it. So it was a case, but he lost. But not by far.
Yeah, a case but lost, so we all win.
File it in proper, and then decide.
Or do you have a lawyer? Oh, I guess you didn't know that, did you?
I've read several summaries of this, and none of them have said if a lawyer did it for him. But I've got to presume he pulled that number out of his armpit somewhere.
I think he was not represented.
That would be my guess, but I'm just guessing. But it was, in fact, a case, but it didn't get very far.
Yeah.
Right.
If you are the lawyer who represented him in that suit, please call in, and I think we have a guest spot on the panel, right, next week?
That's exactly right. We're going to talk about other lawsuits that you can bring, like maybe the wind causing damage to you and suing the wind.
To your hair.
Or suing God.
Donald Trump's hair.
Suing God. What's the guy that sued God?
Yeah.
The one North Carolina or South Carolina?
A prisoner.
Prisoner tried to sue God. Yeah. So I think we'll bring it up. Look, what is tribal sovereign immunity? That's what people always ask. As a personal injury lawyer, you know, throughout the United States, what do we have out there? We have all kinds of, it used to be, Reno, Las Vegas, the Atlantic shores. They had the big casinos. What are the big casinos now?
Indian tribes.
Where they want to be.
That's exactly it, the Indian tribes. So what's happened is a lot of people slip and fall or get injuries while they're at the casinos. And I get those calls all the time. And you know what my answer always is? No, I will not take that case. And why do I not want to take that case? Tribal sovereign immunity. And tribal sovereign immunity, I'm going to give a general overview of what it is, not details. Again, as we state, and we haven't said it this hour, we're talking about general areas of law. If you have an issue or a question, call your local attorney and get help, because there's so many facts and details we need to talk about. But tribal sovereign immunity is basically a tribe is a government, is a country within a country. And so they act as their own country, and it's very difficult to sue them and under these tribal immunities. And there's a couple of things you have to understand under tribal immunities. Number one, they get a lot of they can get a lot of cases basically thrown out. And so people like that if they want to get protected, and a lot of times they'll try to sell things or transfer things to an Indian tribe or a government, some sort of tribe, and say, hey, pay X amount of dollars, we'll be partners on this. And then to sue them is going to be difficult because they have all these immunities. So, but there are some exceptions. They can't, like, for example, the government can sue them. So they're not immune from the United States government suing them. You can still sue them civilly, but there are all types of hoops you're going to have to jump through. And we don't have time to sit here on Radio Law Talk and go through them, but it's just very difficult to win. And I bet you there's 2 or 3 lawyers yelling out there, oh, I can do it. Yeah, I know how to do it. Let me show you how to win those things. They're tough, man. They're tough to win. But there's other things, like, stuff like the Clean Water Act. They still need to follow through with some of these laws, the Safe Drinking Water Act, Resources Conservation Recovery Act. But Congress has to, if there's going to be any change, they have to basically make it a complete and clear change to the immunity. They have to say basically, look, there's no immunity for this reason, or it's unequivocally not covered. But anyway, Congress has never taken this immunity away from the Indians or Indian tribes. So
I have a question for
Sure,
you. Does
sure.
it only apply to the tribes and not to the individual members, or does it apply to both?
The tribes. It applies to the tribes.
All right.
But individual members. So you can sue an individual person that's a member of a tribe, absolutely. But the tribe itself is an entity that is protected. And so under a number of immunities. But there are little minor exceptions here or there. But so, for example, the states, generally speaking, now even though the United States can sue the tribes, it doesn't mean they can't be sued, don't get me wrong, but to win is going to be difficult. But a state, it's going to be more difficult for them to win against the tribes. But the federal government has got more strength. So why are we bringing this up, and whether or not a tribe has immunity? This case, we've been discussing and we've been banging out, talking about, studying, reviewing, is the St. Regis Mohawk tribe is a co-plaintiff with a small tech firm called SRC Labs. So what it is, basically a Native American tribe, along with SRC Labs, sued the tech giants Amazon and Microsoft, claiming patent infringement for Restasis. Now, Restasis is what? It's a type of what do you call it for your nose? Just space.
It's a dry eye.
No, dry eye. That's on it. The dry eye stuff that you can, and they have a patent on it. And so to make a long story short, what they're doing is they're trying to figure a way to protect their patents. And so not just anybody out there, but including, you're going to have those, what do you call them? The generic brands that'll put generic brands out. So they transfer some of their ownership and rights to this Native American tribe called the St. Regis Mohawk tribe that owns a casino. And by the way, the statistics and the facts show that the casinos are doing what in the United States? There's so many being built, these tribes, casinos, that the revenue's starting to go down. And so what they argue is, we're doing this for one simple reason. We're just diversifying as a tribe. We're not there to protect and make this kind of I'm not going to call it sham, but to protect our partner from protect their patents. But in essence, that's kind of what they do. They do that. And so that's what this whole tribal sovereign immunity doctrine is happening in this case. And so
it's being used as a shield to keep the defendants from challenging their copyrights or patents by the patent office, right? That's what copyrights, but patents.
That's, the other people are arguing that, but they're arguing, the tribe is arguing, and what is it, the P, whatever the name of the little, is it P, I got to turn back and look at the actual name of it's a little tiny, SRC Labs is claiming that. So they're claiming that, look, we're not doing it for that reason. We're just trying to diversify. We're not trying to do it to protect these copyrights.
We're trying to diversify, and we're actually sharing some of the revenue with the tribe who's suffering, and they want to use this money for their people and for health insurance. That's one of the things they quoted that they were going to use the money for, was to try to better their
Restasis generated $1.5 billion in sales for this dry eye thing, and talk about money. And what it comes down to, that Let's see. In exchange, the allergen agreed to pay the tribe an initial $13.75 million and $15 million for every year the patents are still viable. So they're trying to protect these patents, to make a long story short. And we're going to talk very briefly about what happened when we come back in the next segment. But it's just interesting how these the Indian tribes are using their sovereign immunity to protect these businesses and their patents. And we'll be right back.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penny.
We're talking about tribal sovereign immunity and how this is used in cases to protect patents and to protect trademarks, et cetera, et cetera. And we start talking about the St. Regis Mohawk tribe being used in one of the cases, but there's actually multiple cases in which they use this. One is the restasis we talked about, which is the dry eye issue that they're trying to protect their patents there. And also there's the SRC, which is more of a tech thing that's related to protection of their patents, etc.
Yeah, supercomputer patents.
But it all stems around using this tribal sovereign immunity by bringing in these Indian tribes as pseudo partners. Isn't that correct, Todd?
That's right. What the company will do is they have a in one case it was a drug, in the other case it's a supercomputer system, a tech thing, and they assign the patents to the tribe to try to get some sort of protection for the tribe, and then the tribe then makes a reciprocal agreement with the company for the licensing and protection and money. Yep. So it's just a symbiotic relationship. We talked about Allegren and what happened with Dry-Eyed. SRC was a company that came up with a patent, and they had a patent for what's called a system and method for accelerating website access and processing, utilizing a computer system incorporating reconfigurable processors operating under a single operating system image.
Okay, Chris, go ahead, Chris. Why don't you delineate a little more detail on that?
Well, I think Todd did a good job.
So you have this.
I fell asleep in the middle of it. It was great.
So you have these patents and a couple of others, and SRC assigned the patents to the tribe to get this protection, as Fred described, because tribes have a different legal system to deal with sovereign immunity.
That's right.
And then the tribe went back to SRC and said, all right, well, if you're going to give that to us, we then go back to you and enter into an exclusive licensing agreement with the right to sublicense this product. And the lawsuit that we're dealing with that's been filed with regard to the tech is that Amazon and Microsoft are both using the same technology for which SRC, via the Indian tribe, has a patent.
Yeah.
And that's why Amazon has been pulled into this, and Microsoft is because of this copyright infringement. But you see how complicated it gets by bringing the tribe in, and now it's a different set of laws because of the sovereign immunity, and things get a little difficult there.
That's true.
This is a very complex topic. And one of the things that's at play here is something called patent trolls. And I don't think we've ever talked about it. And
it's interesting.
It's somewhat interesting. So there is a whole industry out there, and it'll probably make people hate lawyers even more than they already do. But
guess what? November 3rd, don't forget, I'm reminding you again, is Love Your Lawyer Day.
Okay, Love Your Lawyer Day. These patent trolls, basically, there's all kinds of patents that people try to file, and it's really not all that hard to get a patent issued. The hard part is whenever you try to fight somebody on whether that patent is valid. So let's say there's a company in Denver, Colorado. It holds 1,000 different patents in all kinds of different things because it purchased them for very cheap.
Right.
It doesn't do anything. This company does nothing but hold patents. And then it looks out there in the industry and it sees who's using technologies that are similar to the patents that it holds, and it files lawsuits.
Nice.
It files a lawsuit against, in this case, Amazon and Microsoft.
Right.
All right. But there are patent trolls that file lawsuits against all different kinds of people.
Even small mom and pop.
Actually, are doing business.
Right.
And then it gets money by nuisance value settlements, essentially, of these patent lawsuits.
Yeah.
So the company does nothing but holds patents, sues on them, and then collects legal settlements. And that's what these patent troll companies do.
And now the patent trolls are trying to take it one step further so they can give their money or assign these patents to Indians, tribes, and get sovereign immunity so that they can't have their patent challenge.
That's right. So they are increasing the settlement value of their patent troll lawsuits by partnering with an Indian tribe that has certain characteristics relating to sovereign immunity that make it harder to defeat them in litigation.
Amazing.
Has anybody assigned the likeness of Michael Jordan to an Indian tribe for purposes of an $832 million lawsuit? Just a question.
That case would still be worth zero.
Okay, good.
Well, they can do it improper, anything they want.
Well, yes.
But you know what? What's interesting about this is people don't realize how the lawyers think about some of these things. It boggles your mind sometimes. They got to be sitting in the corner. And you know those guys in law school, those gals in law school, we've all had them. Those are the ones that love to sit in the corner and just study and research and do stuff like that. Those are the ones that come up with the stuff, not the ones that are out there are trying cases. They're the guys sitting and gals sitting in the corners.
You know, this is where we see, because the average person, probably the average person listening to the show isn't going to deal with a patent infringement like this, but they will deal with, regrettably, the we'll call legal trolls, what Chris was talking about. I'll give you a couple of examples, and this is stuff that cost a couple of attorneys their law licenses. Well, he said patent trolls. I'm talking about legal trolls, where the same idea goes beyond just patent law. For example, the lawyers that decided it would be a good idea to start suing the mom and pop or the little salons because they didn't open up a new bottle of nail polish every time they put nail polish on, and they sued them all under the Unfair Business Practices Act as a private attorney general, and then settled this to induce these $5,000 settlements to try to go ahead and get money this way. And they were suing all these individuals who didn't want to hire an attorney for $10,000 to defend themselves, so they were shelling out $5,000. Fred, that was literally a group of guys that got out of law school and decided this was how they were going to make their fortune, and their bar card didn't last very long. It took a couple of years and they were out. But there's that type out there. You also have people that sue under the Americans with Disabilities Act. You know, they go around to various places and they go in because they spot violations, and then they take their individual that works with them who is handicapped, they have them go in, come back out, they fill out the affidavit that they were emotionally traumatized because the toilet paper dispenser was too high or whatever it was, and that happens. And so we do find people that end up becoming victims here to these kind of lawsuits from professional plaintiffs.
You know, I defended successfully one of those American with Disability Acts case, and unfortunately in that case, the troll, if you will, he did die during the pendency, and it was deemed that it was a personal action and that his estate could not continue on.
Right, that is the only way that you can successfully defend an ADA lawsuit, is if the plaintiff dies in the middle of it. So good on you.
Yeah, at least I knew that.
Not that we are giving any suggestions as to ways to defend against the lawsuit, should you ever find yourself as a defendant in a lawsuit. Thank you very much, Chris Rodriguez.
Don't worry, our insurance agent out there is going, I think they're still covered.
Yes.
I know I signed that. Hey, listen really quickly. We're almost done with this hour, our third hour. You definitely want to talk about Johnny Depp, about his lawsuit against his lawyers. I know you think, what do we want to talk about that?
Yeah, next hour is going to be
Are we going to probe the depths of that?
Yes, we are. We have 3 minutes left. I want to bring up really quick the Honest Ads Act, because it sounds like Honest Abe, and that's why I laughed about that. But the Honest Ads Act basically is coming down. It was brought. John McCain is one of the.
It was a bipartisan.
Yeah, it's bipartisan. They're trying to change. It all came down with the Russia issue of whether or not the Russians were involved in the last election, and we're not going to get into that because, you know, Radio Law Talk, when you're tired of politics radio, turn into us. But here's the issue. The issue is things are changing so fast in technology. You go back and read the Federal Election Campaign Act of 1971. Your horse-drawn wagon must be so high and so low. You know, it's all these old technology. The Yellow Page ad must say this or that. So there's nothing in there about social media in any of the acts. And they do talk about TV and radio, things you can and can't do on TV and radio. And Cal, we know, there's certain things you can or can't do. But the act now is changing that and changing the wording to now say.
It's going to now include, it's making it broader. To cover internet and social media and digital advertisement.
That's exactly right. And instead of calling it radio or television, it's called audio format and video format.
Which is any public communication.
Right, and they're using the word any public communication. So they're being more general, so as technology takes off, things are going to be covered. And that's going to be interesting later on, a topic for us that we're going to have to talk about probably within a year or two if we're still alive and still on the radio. But and our salaries are probably increased by then. We're going to talk probably more about that as the time comes. So we're bringing that thing up so you understand what's going on.
Where else can you hear about patent trolls, political ad laws that are being changed, Johnny Depp? I mean, we cover it all here.
We do.
It is schizophrenic, if nothing else.
Radio Law Talk with C-Rod and the Prince of Harvard.
Hey, thank you to Sydney Colbert from University of San Diego School of Law. She did our research today.
You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
When you're tired of politics radio, join Todd, Fred, Denise, and Chris and talk about radio and talk about law and talk about how it applies in our lives. I'm Frederick Penny, your host. Appreciate Cal being behind the glass, our illustrious producer, taking care of us. That's exactly right. And he's the one that plays the music and the roll-ins and screws up sometimes really bad. And it's kind of embarrassing. But
it's terrible. Yeah, it's the worst. Yeah.
Well, it's the problem is what we're paying him. Again, it's just so much overpayment that he's sleeping half the time.
I'm never ashamed on payday.
That's this is our third hour. We love being on the radio. We like to welcome other stations that are joining us this third hour, including K-High out of Auburn. But we like to especially thank Crack and KBLF, our sister stations up north near Reading and Red Bluff. We've got exciting news. We've brought it up before, but starting November 11th, we will be on the Nevada Talk Network, radio network. Woohoo! So we're going to start covering pretty much most of Nevada with Radio Law Talk. And more coming after that. Everybody wants us to be on there. Let me back up. I don't want to say everybody. My wife says I exaggerate sometimes. But there's a lot of people that want us to be on their stations because they love Radio Law Talk. And it's growing and expanding, and we're excited about it. And it's a fun time we have here. We have fun talking about the law. Try to make it so it's not so boring, because sometimes the law is boring. But we just have fun, don't we, Denise?
We do. We just try to break it down for everybody.
Yeah. And so, Denise, tell them how they can get in touch with us.
They can get in touch with us by calling us at 855-LAW Radio or tweeting us at Radio Law Talk.
Yeah, tweet us at Radio Law Talk. We have a thing called Case or No Case that we're going to be doing pretty soon here, where Cal Hunter, our producer, three-time Emmy Award nominee but never a winner.
Thank you.
He gives us a topic and not a topic but a case, and we got to determine whether, well, first of all, it's a case and whether or not they won, and we're going to determine which of the lawyers here are stumped or not stumped. But if you want to answer, tweet us and tell us your answer at Radio Law Talk. Remember, we're talking about general topics of law. Seek counsel from a local qualified attorney for anything that you need concerning the law. The most important thing that we've been bringing up is November 3rd, 2017. Let me repeat that for you listeners. Again, walk over to your calendar. Hold on. Let's wait a second while they walk over. Okay? You're walking over to your calendar. Pull your calendar out. Grab your pen, listeners. Very important. The 3rd of November, 2017. Chris is like, oh, get to it. Love your lawyer day. Love your lawyer day. Oh my gosh, I didn't know there was a Love Your Lawyer Day, but I just found out. It's exactly right.
My office is filled with teddy bears and
Already coming?
Absolutely.
Love Your Lawyer Day. And Rodriguez said, what can we do in order to help out or make Love Your Lawyer Day better? And Chris Rodriguez said, pay your bill. And then Todd, what did you say?
I said that your Google search does not replace my law degree.
Oh, that's true. That's true. And Denise just said...
I just said it took a congressional act to get a Love Your Lawyer Day. Can you believe that?
And most of them were lawyers, so what did you think was going
And here's the best part about it. It's been all over the news. They're talking about it.
Oh, yeah.
It's such a big deal.
It's a red hot holiday.
Well, it started in, 2003? And I'm just learning about it now. I was wondering why I got all those cards November 11th from my clients.
Is there a Love Your Congressman Day?
It's the same day.
Same day.
It's same day.
It's the same day.
Love the Devil Day.
Love the devil, Congressman. That's exactly right. That's
Nice.
Chris Rodriguez. That's why we invite him here. Today we're going to talk about some really cool stuff. Today we're going to talk about Johnny Depp. Well, back up today. The third hour we're going to be talking about Johnny Depp. We've kind of held this off our first and second hour because we have a number of people that join us third hour. And Johnny Depp sued his lawyers and his, quote, management company that, by the way, happened to be owned by the lawyers on a number of occasions. And we're going to get in detail about the complaint. We've actually read the complaint. We've studied the complaint. But you have to realize when we're talking about this, they have not answered. Chris explained kind of what type of possible answers, cross complaints, and how just the general process works. So the complaint has been filed. By the way, I think the defendants knew this was coming, and so they were kind of throwing out some publicity prior to this.
Yes, actually, and one thing that we need to clarify here, the complaint that we have been working off of is a complaint that was filed October 17th, 2017.
Right.
And it's in California.
Now, note this. That was filed against Bloom, Hergott, Deemer, Rosenthal, Feldman,
it's a law
and
firm.
litany, okay? Now, the original complaint by Johnny Depp was actually filed in either late 2016 against the TMG group, and I have it, and I'm having it printed up right now because we already have a response from the TMG group and a cross complaint from them where they allege all the stuff that Depp has done, and that's where they brought out all of this. You have been spending extravagantly. I'm sending it to Seth so we can get that printed out.
Yeah, here's the key. TMG is the management company of the law firm that Johnny Depp hired. So Johnny Depp hires his lawyers to take care of him. It's a Hollywood firm down in Southern California that handle a lot of stars, and he's suing them and TMG, which is their management company, in order to saying that all kinds of fraud occurred, and not only fraud, but what else? There was a whole litany of things. No, there was self-dealing, all kinds of issues.
Breach of fiduciary duty, legal malpractice, unjust enrichment, violation of 2 different sections of the California Business and Professions Code.
Which Chris is going to talk about in a little bit.
Yeah, I mean, basically it boils down to when the lawyers sitting here, and most lawyers in this country take these obligations seriously, you have an obligation to your client to put your client's interests above your own.
Right, and the key that's important here too, and that's why I'm bringing this up at this time, what we're working off is the complaints, and this is all stuff they allege. And in fact, you'll see in these complaints, that are 40, 50, 60 pages, a lot of it says alleged. So the fact that we're talking about this, we wanted to throw this disclaimer out there that this is what's being alleged by Johnny Depp, this is what's being alleged by Johnny Depp's, new counsel, and then we're going to have, I keep wanting to say TMZ, it's not TMZ, it's TMG, are alleging things in the original complaint. So that's what's happening.
Right, but all of these allegations are basically accusing the lawyers of putting their own interests ahead of their client. For example, arranging for Johnny Depp to take a loan from the lawyers.
Right.
to, basically having the lawyers loan Johnny Depp money that he didn't need to borrow and pay exorbitant amounts of interest.
Right.
So that's a conflict of interest where the lawyers are putting their own interests ahead of Johnny Depp's.
Right. Well, let's back up, Chris. On page 12 of the complaint, they go through California Business and Professions Code 6147A and California Business and Professions Code 6148. 6148, and again, we try not to bore you with this stuff, so we're going to generally talk about it, but 6147A is basically protects clients from and provides that you kind of have to have if you do a contingency basis, you have to have a fee agreement.
That's right.
And same with 6148 is if you don't do a contingency, it's just how the bills are going to be paid and the expenses. So why don't you explain that just very briefly, Chris?
Yeah, real quick, because we got to go to break here in a second. But basically, if you are going to, as a lawyer, be compensated by your client based on a percentage of income that they're receiving, that agreement has to be laid out in writing. All the pros and cons have to be disclosed, and the client has to sign it. And so what they're saying here is Johnny Depp was being charged a percentage of revenue coming in without being presented and signing off on an engagement letter that said that.
We'll talk more about it when we come back from, this is Fred Penny at Radio Law Talk. This is interesting stuff about Johnny Depp.
Stay right there. There's more Radio Law Talk coming right up. All around the world. This is RadioLawTalk.com.
So we're talking about the Johnny Depp lawsuit. This is really interesting because there's multiple lawsuits here. There's a lawsuit that we're going to talk about was filed October 17th, 2017. Basically, Johnny Depp suing his lawyers. But prior to that, in January 2017, there was a lawsuit filed also where basically his management company, sued Johnny Depp and talking about all the different things and allegations about what Johnny Depp was doing or not doing. But we're jumping forward to the October 17th, 2017 lawsuit where Johnny Depp is suing his lawyers for basically doing inappropriate things. But here's what's interesting. So, and I said interesting too many times, but my co-host here is going to slap me because Denise hates it when we say that. So about in 1999 is when Johnny Depp hired this law firm, and I'm not going to even bring up the firm's name, but hired this law firm, this lawyer, to basically be the lawyer and watch out after his finances, and then what happens? They're supposed to review contracts, and then there's so much that's going on. And this complaint's about 30 some odd pages long. He starts arguing that they give him in this hard money loan, basically a loan shark, where it's a 22.22% interest rate, and his lawyers get him to sign off on this, and Johnny Depp claims that he just signed the last page, didn't really know what it was
never explained to him.
Never explained to him, and who they're loaning this money from is another company. Those lawyers have some
the lawyer
ties.
sits on the board.
On the board. It has some ties, and it has some sort of ties with this company. And so Johnny Depp suing, saying basically they're colluding and not informing of him of all the information. There's not even, under California laws, what we went over before the break, you have to have a signed contingency fee agreement, and these lawyers are getting contingency fees on his movie deals and on his
they're getting cutbacks,
yeah,
maybe not even necessarily for fees. They're just part of this transaction, and they're getting royalties. It's almost like royalties.
Well, what his royalties are, they're getting a cut of the royalties.
Right.
And to top it off, this is all in the complaint. Don't forget, this is what Johnny Depp's complaining about, and in his complaint, they're also saying that the lawyers are getting paid first, even before Johnny Depp gets paid. Basically, they're the first ones getting the handout before it comes to Johnny Depp, which is not what's good for the client. The other argument is they're trying to claim is that, hey, you get this 22.22% loan plus. I guess there's also administrative fees, et cetera. Why didn't you take care of going out and getting 3 or 4 other loan options that we could at a lot cheaper rate? And he's claiming they didn't do that. Not only that, he's also claiming that they're turning in receipts I mean, they're asking for reimbursement for costs, and literally they're just writing them checks. And there's a person testified that was working for the TMG, which is the management company, said, yeah, I wrote checks out that were basically hundreds of thousands of dollars, and
there's no receipt.
No receipts. They just said pay it. And so there's that testimony against the lawyers that they're not protecting them doing it. Just, well, do you have a receipt? Here's the accounting person saying, well, do you have a receipt? No, just pay it. And so Johnny Depp's claiming that's going on. Here's another thing. Further, they get these loans for, at first, was it $12 million at first, and it went up to $19 million in loans. And then guess what they used? They used his royalties from
Pirates of the Caribbean.
What's the other ones?
I think it was Alice in
Wonderland. And what's the other? Then there's one of his other movies.
Willy Wonka?
Willy Wonka. That's exactly right. And what's interesting, he was going to get paid $5.58 million right around the time that they take this loan out. So in other words, within 8 days after the loan, $5.58 million was coming in, and they knew that. So why did they take these big fat loans out? And because he's saying they're self-dealing because they're getting cutbacks on these loans.
Right.
Kickbacks on these loans.
They have relationships. The defendants have any relationships that they have not disclosed, which creates conflict of interest. And they have a high fiduciary duty to Mr. Depp, and they did not disclose these different things to him, breaching their fiduciary duty. So there's lots of different things that's been alleged.
Let's step back and look at this. This is alleged to have taken place over 16 years. So it's pretty evident, and I bet you this happens a lot in sports and in Hollywood. Johnny Depp was making so much money, probably still is, and he didn't want to worry about the day-to-day things like paying bills, like investing. So he hired Mandel and a bunch of lawyers, and over 16 years, he paid this TMG firm $28 million over 16 years, and basically expected them to take care of everything. And then when he gets himself into financial problems, you go back and you dig into this relationship, and nobody did. I mean, there may have been some maliciousness here. It sounds like the allegations are that there was, but now they're going to go back over that 16-year period, and they're going to fly spec every transaction and make as much of it as they can, because obviously he's not in a good financial position right now.
Yeah, what's it? Go ahead.
Right, and well, when they filed their, initially he filed against his management company and some other people, not just the lawyers, but when he filed that action, they countersued by saying, hey, we actually warned Mr. Depp that he was excessively spending money.
Yeah. And we're going to get into that in a minute, Denise, and we're going to get into that.
Okay.
But the other thing that's interesting that we want to continue on is the complaint that Johnny Depp says is this 22.22% interest rate, hard money lender, guess what type of loan it was? It was the type of loan that there's prepayment penalties, so he can't pay it off. He's got to keep paying this high interest rate. Now,
and it's gone from the initial 12.1 to all the way to 19.
And the answer is he can pay it off, but I mean, it says you can't, but if you do, you get penalized up to $1.9 million in penalties. So they put him not just in a loan, but you're not allowed to accelerate and pay the loan off. You have to continue to pay these high 22.2%, and to top it off, they're getting kickbacks. And this is all he's saying. So anyway, and it goes into all types of issues that Johnny Depp is trying to assess these lawyers on. Now, not just TMG, his separate management company that they were somehow involved in, but also his lawyers. And so what we're going to do is we're going to talk more about this after the break, but it gets even more interesting to talk about what now they're claiming Johnny Depp did wrong in this whole lawsuit.
Go to the website, radiolawtalk.com. You can listen to the show there, and there's a lot of other good information, too. That's radiolawtalk.com.
We're still talking about the Johnny Depp lawsuit. He's claiming that now this is the one that's just shocking, and again, this is what he alleged, is that his management company and or mainly his lawyer, the lawyer had a professional relationship with the hard money lender. In fact, he eventually apparently became on the advisory board of the hard lending company. So here's his lawyer getting him into this hard lending company and paying these percentages and these high rates, and then he becomes a member of the advisory board. Now, what's interesting, and it sounds like he wasn't before, but he became a member of the advisory board. And so that's what they're arguing is shows that there was a conflict before. They knew each other. But here's on page 10 of the complaint. Go ahead.
Well, when you have a conflict of interest as an attorney,
You have to
disclose it. You have to give informed written consent, which
Right.
means not only disclosing the fact, but also disclosing the potential conflicts that could arise and what could occur to the person, and in addition, tell them that they have a right to have this reviewed before another attorney, and they have to sign an informed written consent.
Right. So here's some interesting facts about Johnny Depp. $3.1 billion he's brought in the box office of the United States. Again, that's just the box office. That doesn't include all the other ancillary things they make money on. $7.6 billion worldwide he's been able to bring in through the box office. And, he's the main actor. Let's face it, he's the guy that makes these movies. But on allegation section, let's see, page 10 of the complaint, number 39, over approximately 3 years, this is what he claims. I got to read it because it's just so interesting. This just boggles my mind. Over the approximately 3-year period since this loan was initiated, Mr. Depp should have received a total of approximately $32 million in residuals from the films. Instead, Mr. Depp received nothing. $9 million of his film residuals were directed to the payment of Mr. Depp's tax liabilities on his contingent earnings, with the balance being paid to defendants TMG, Mr. Depp's agent, a third party, and the lender to whom the defendants, that's the lawyers, also had and have an undisclosed professional relationship with. Moreover, Mr. Depp still owed, they're claiming, the hard money lender is still claiming that Depp owes $5 million in the hard money loan, which continues to capitalize substantial interest at an unreasonable rate. Now, also, what happened is they tried to go against his home because he apparently wasn't paying on it or whatever. This is a battle, and they tried to do a non-judicial, whatever that means, a foreclosure on his home.
Well, I can tell you what that means.
Go ahead.
Non-judicial means you don't have to involve the judge.
No, I get that, but I don't know. I don't understand.
That means they had to have a deed against the house.
They must have already been done.
They had a deed against his house, because if you do a non-judicial deed of trust foreclosure, you have some right to that property, and maybe some of the money went into that property or something, but they had a deed and a promissory note.
And one final thing before we get to a couple of things that Todd wants to bring up. So they have the testimony from the accountant of Johnny Depp's accounts that these lawyers would come and ask for a reimbursement of their costs. And this is what she said. It said, defendants submitted the request for expense reimbursement. This is the defendant, he's suing his lawyers, with little or no supporting documentation, which TMG would then pay without question from Mr. Depp's fund. And this, she states, the accountant says she was ordered to, quote, just pay it. Defendant's expenses and requests for reimbursements were never sent to Mr. Depp for review and approval. There's some serious allegations here. So that's what Mr. Depp is claiming. And again, there was an earlier lawsuit against Chris that was against not the law firm, but against his management company.
The management company, which the Mandel brothers own, and the Mandel brothers happen to also be attorneys.
Right.
But their cross complaint that they filed against Johnny Depp said, hey, we never acted as his attorneys. We were his managers.
Right, so let's go into that now, and let's talk about that with Todd and Denise about what they claim in the lawsuit. So there's 3 lawsuits going on here, just so you know, folks out there getting confused and going in circles. There's
3 complaints.
3 complaints. I mean, that's what I want.
It's one lawsuit with 3 complaints, and the cross complaint.
Well, is it one lawsuit or is it 3?
It's different. So you have a lawsuit filed by Depp on January 13th. Okay,
But it's a different case
and
number.
it's a different case number, and that's filed against the management group. And then you have the cross complaint from the management group filed against Depp with the same case number back in late January.
January 31st,
Okay.
20.
So then you have another complaint under a different case number filed by Depp against the attorneys
Right.
that was filed October 17th. And you can bet, because that was just a couple weeks ago, we have yet to see the cross complaint that will undoubtedly be coming, where the attorneys are cross complaining against Depp. And so at that point, we'll have two case numbers, two complaints, and two cross complaints.
That's exactly
And
right.
they're going to have to be consolidated because
Yes.
the issues are really similar.
So you explain what that means, Denise, what that means.
That means that they're going to put these two cases together for purposes of trial. Even though not all the defendants are the same,
Right.
there are similar issues and similar facts such that it would be judicially more economical if these cases were tried in the same.
And they bring that's a motion you bring before the court, and you ask the court, sometimes they'll stipulate to
Yes.
it, the plaintiffs and defendants, just to make it all one and make it simple, which should happen here.
And I believe in reading so far that the same Superior Court judge has been assigned both cases. The biggest issue is going to be if there's a consolidation at trial for everything. So I believe Judge Susan Bryant Deacon has been assigned both cases to be heard in her department. Whether or not they're heard on the same day right now, so far, I don't know, but I agree that at some point in time there will be a motion to consolidate them, and then depending on which side feels it's most advantageous to consolidate them and which side feels it's least advantageous
I would
to.
love to be the judge on that, wouldn't you? I don't know why.
be
I've been reading this, Denise and I and Todd and Chris, we kept shaking, this is fascinating. We were talking about it.
Yeah, I did want to say, before we get a little bit more into this, a lot of people might be wondering, well, why does a guy need to have a business manager? I mean, if you do a film for $20 million, you get your $20 million, you put it in, maybe you've got an investor or a broker. Why do you need all of this stuff? And there's something that you have to understand about the entertainment industry, the sports industry. There's a lot of stuff that goes on when it comes to your income. Fred, you were talking about residuals and how it was 30 plus million over a 3-year period and it didn't go to him. Okay. Residuals. Johnny Depp right now has 80 film credits under his name, of which we've got like 3.whatever billion you said collectively.
In the United States only.
Yeah, so he's got 80 film credits.
Let's back up. Not those. That's just the ones that were, I believe those are just the ones, those Disney ones that he had done.
Okay, so, but all told,
tons.
All told, he has 80 film credits. He has 10 projects upcoming. He has 9 producer credits, 12 soundtracks, 3 director credits, and 1 writing credit. And the way it works with the Screen Actors Guild is you get paid your money up front to do the film, and then you get your residuals. And maybe you've negotiated that instead of the residuals, you get a percentage of the gross profits. Bruce Willis made a killing back when Look Who's Talking came out because he agreed to take less money but have a percentage of the profits.
Right.
And that's what put him on the map financially.
And that's what Cal's doing with Radio Law Talk.
Exactly.
So the business management company then is really needed because oftentimes these actors will create different companies
Right.
for the different producing or the acting or that type of stuff.
And Johnny Depp has a number of them.
And it
Yes.
gets even more complicated because if your film was produced and you did your work in New York, now you have to pay income tax in New York. And your residuals have to be spread upon what state you were in when you made it. And he's got 80 film credits.
Yeah.
Pro athletes, when Alex Rodriguez signed his $250 million with Texas, he had to have accountants go and figure out how much money he would owe in California for the games played in California.
A lot.
And how much he would owe in New York as they traveled
Wow.
because he owed income tax in that state because those contracts are paid. You're paid per game. And that's why they need these business managers, because at 80 film credits, there's no way he could keep track of this all on his own.
No.
Absolutely not.
But what is alleged here is not typical of a management company. In addition to the stuff that Fred was talking about, Johnny Depp's managers and I use that term loosely, were lending money without Johnny Depp's consent, $700,000 to somebody who wanted to do a kitchen remodel.
Which is what makes this terrible. You have a person in a situation like this who needs this.
Well, I needed money then, Rodriguez. I needed help with my kitchen. So
It's a beautiful kitchen.
But
That's an allegation.
he needs this service because he can't take care of it himself. And the entity that he goes to trust them with all of this is now alleged to be doing these dealings behind his back with his money. And that's why, I mean, if they'll rip him off, allegedly, they'll do it to anybody, which is why we have these suits. But we are up on a break here, Fred.
Yeah, let's talk more when we get back from the break about what they're saying Johnny Depp did wrong, and that's going to get interesting.
And why they're saying it.
And why they're saying it. We'll be right back with Radio Law Talk.
Radio Law Talk.
Radio Law Talk. I like show me the money.
Now back to RadioLawTalk.com. Here's Denise, Fred, Chris, and Todd.
Hi, I'm tweeting a picture. I've got to tweet this picture. Todd study, look. All right, I'm tweeting it right now. Tweet. Those of you who got Twitter, go to our Radio Law Talk Twitter page and see the picture of Todd reviewing. Look at this. Look at him review. He's looking at the paper.
That's funny.
And it's just hilarious. Okay, we're talking about Johnny Depp. And we really want to get into the allegations that they're bringing against Johnny Depp, like his management.
I like
team.
Jolly Depp.
Jolly Depp. Jolly Depp and Johnny Depp. His management team's bringing against him, and or what the attorneys, I'm sure, are going to also bring against him when they answer the complaint and cross-complaint. Go for it, Denise.
Okay, so they brought a cross-complaint. The Mandel company that does business as the management group actually cross-complained against Johnny Depp and various of his business entities, as well as his new CPA. And so that's kind of an interesting. Yes, in other words, under the management company, there was a different CPA. And so when Johnny Depp left the management company, he also left the CPA, and he then has a new CPA. And they are alleging, the management company, the Mandel Group, is alleging that Johnny Depp had excessive, irresponsible spending habits, that he was constantly advised about he needed to cut down his spending, that they warned him repeatedly to stop spending.
Did it talk to him about what type of spending?
Yes, and he was spending $2 million per month, and he spent in excess of $75 million to acquire and furnish 14 different residences.
Wow.
And that he had spent $18 million to acquire and renovate a 150-foot luxury yacht. He was spending $30,000 a month on wines and personal consumption. He was spending over $30 million for a specially made cannon that held the ashes, or to put the ashes of Hunter Thomas over Aspen, Colorado.
Who's Hunter? I'm sorry.
He's an author.
Hunter Thompson.
I'm so sorry. Yes, it's Thompson, as a matter of fact. And then he spent millions on collectibles, and he was paying for 40 full-time employees around the world $300,000 a month just to maintain his homes. And in addition, he supported his friends and family to a cost of over $10 million. And
now that I believe. I mean,
yes.
that's NBA.
But hold on here.
Okay.
Can I jump in?
Jump in. We're gonna talk about
what is the difference between what Johnny Depp is alleging and what is being alleged against Johnny Depp?
Right.
It's his money.
It's his money.
He can spend it however he wants to spend it.
And he doesn't owe a duty to his management team.
Absolutely. What
They're
trying to get a reaction from the public to say, or from the jury, look at what this guy was doing with his money.
So what? Yeah.
Who cares?
Right. So you got to hear this response. TMG says, proving that no good deed goes unpunished.
Oh, is that what he's saying? Is that a quote?
Yes.
Oh
In
my
a complaint.
gosh.
It's page 3, paragraph 15. Depp, with no notice of any kind, terminated TMG's services in March of 2016. Depp then refused to pay TMG back on a $5 million loan they made to him in 2012 when the actor was facing public financial ruin. And then they blame it completely on his new CPA. They said that they repeatedly tried to contact Depp through the CPA and repeatedly tried to disclose things to the CPA, but that all the attempts to reach him through his new CPA, Edward White, was never responded to. So I was trying to shift the burden a little bit on Edward White. And then they said left with no choice, and Depp still owing $4.2 million. So they started non-judicial foreclosure proceedings against certain of Depp's property. Okay, that's very, in my opinion, very a drastic step, okay? And then they go through, and it's really an interesting cross-complaint, because they go through and they say every allegation that Depp has made against them, and then they said false after it, and then they said this is what's true. So this is what they're claiming is true. Although both Mandel brothers are attorneys by training, they never acted as Depp's attorney, never provided him with any kind of legal advice. There was no attorney-client privilege. That's the start of it. And it goes through, and it's interesting reading, but it's a lot of reading because it's a long cross-complaint.
Chris, tell us what you really feel, Chris.
But Chris, if they're acting as his agent in California, are they not acting as an attorney in that case?
I'm not sure what the difference would be, whether they're acting as his attorney or as his manager. They're going to have a fiduciary duty to him regardless to act in his best interest.
I think the big issue here for purposes of that, and Denise touched on it really quickly when she said it, is they don't want to be accused of violating the attorney-client privilege. So we're not acting as your attorney by doing this. So we can make these allegations. You want to go public, we're going to go public. We don't have an attorney-client privilege that precludes us from saying things to defend ourselves that you would later come back and say, well, you can't talk about that because it's privilege. I think that's the big thing. As far as the fiduciary duty is concerned in California, if they're their agent, you better believe they got a duty to act accordingly with the client.
And the duty would be no different for if it's a lawyer or if it's an agent, and Todd's exactly right. That's probably why they're doing it, is to be able to disclose information that if they were his lawyer, they would not be able to disclose.
Yeah, and this is the interesting thing. We were wondering if there was ever any written contract between this management group and Depp, and they agree that it was only oral agreement. But it was to provide business management services in exchange for 5% management fee on all the monies that Depp earned with an annual cap. And he expressly agreed to this.
Wow, interesting.
Because the Mandel Group has to do this. Otherwise, they're going to have clients leaving them in droves.
Right.
If they think that if Depp leaves and it's proven that all of this stuff happened, they're in damage control because this bad lawsuit could ruin them.
Absolutely. I mean, everyone's going to be jumping ship. Lady, Johnny Depp's house.
Wait a second. Get your head around business managers who are also attorneys who have an oral agreement of this type.
Yeah, stupid.
That's a little bit absurd.
Yes.
He's got a home on Hollywood Hills. He's got downtown Los Angeles. He's got a home.
Who's this?
Johnny Depp. I'm talking about that. He's got one in France. Who do you think he's buddies with? I bet that's right next door to Brad Pitt.
Well, he used to.
And I bet you $5 they had some guy come in and do some lighting studies.
He used to live in France with his former, I don't know if they were married or if it was a life partner, but they raised their kids in France, and when that relationship went sour, he came back to the U.S., but he still got the property there.
That's exactly. He's got Bahamas, he's got a place. So he's got places all over the place.
But isn't the real issue this loan, this acting out? I mean, this whole loan seems sleazy to me. Am I missing out on something there?
Well, we're going to find out about the loan, because I think the loan is really the key and the heart to everything. I think through these processes, they have discovered a lot of information, and I do think, in my opinion, I think that there's going to be problems all around about that loan, the hard money loan.
Right. Again, as I think Chris put it best, it just smells bad because the fiduciary obligation of the lawyers is much higher than like he said, who cares if Johnny's spending extravagantly? That doesn't matter. They still have a fiduciary obligation, and not that his accountants do, his management team does, and so does his lawyers. And I think they're in trouble.
It seems to me, based on all these allegations, that you could almost see the wheels turning inside these guys' head. There's so much money coming in, and all the agreements are so loosey-goosey that they were going to use that money as their own to try and make more money, loaning it to people and doing this and that, and it didn't work out well.
$770,000. Not for a kitchen.
It's $750,000, I think, is what Chris had quoted.
But that doesn't matter. I know that doesn't matter, but it's interesting for the listeners to hear. This is the kind of money. It's just we don't get it. I mean, $750,000 a yacht. How much did he cost?
But that's different things. They lent it to some third person who they don't even give the name to remodel a kitchen. $750,000 with no written agreement.
No written agreement.
Might have been one of them.
Yeah. No, I agree. Interesting. We're gonna find out more about this Johnny Depp, and we're gonna follow this throughout the next 2, 3, 4 weeks, probably throughout the year. I think this is an interesting topic that's going to go on. And doggone it, when you're a lawyer, you got to be very careful. So why don't you thank a few people, Denise?
Okay, I'd like to thank Sydney Colbert, University of San Diego School of Law, for the research that she did for us today. Thank you very much. And I'd also like to shout out to Don Thompson, who really enjoyed our first hour when we were talking about the buildings getting torn down.
That's it. All right, well, this is Fred Penny again, your host of Radio Law Talk. We love this.
RadioLawTalk.com.
Goodbye.
A copyrighted presentation of Radio Law Talk Incorporated.